Committee, today we have a hearing on 3 different bills, all from the Secretary of State's office. And we'll go ahead and get started with opening the hearing on HB 2297. And we'll start with Charles Reimer giving us an explanation of the bill.
Thank you, Chairman. I'm not sure if my video is working. Doesn't look like it is, but I'll just go ahead. I've submitted a brief on this bill, which should be in your information. HB 2297 amends law regarding publications that pertain to the Secretary of State. The primary changes are that the bill permits the Secretary to obtain publishing services in the commercial market. The bill removes requirements that the Secretary set the prices for its publications by the adoption of a rule and regulation. And the bill also permits publication of proposed amendments to the Kansas Constitution in a newspaper of general circulation in a county in circumstances where there is no newspaper published in that county. So going through the section, Section 1 is a new section, along with changes to Section 9 that you'll see later. It permits the Secretary of State, as noted, to utilize the purchasing and procurement provisions of Kansas law to obtain printing and publishing services in the commercial market. Current law restricts that. The Secretary has to obtain an exception granted by the Director of Printing and also the approval of the Secretary of Administration. Section 2 amends KSA 45-106, provides that upon request, the Secretary is to provide 1 copy of the session laws to the Governor, Lieutenant Governor, state legislators, Attorney General, and State Historical Society Library. The current law just requires the Secretary to provide these copies, and so Section 2 changes that to provide that the copies are provided upon request, not just as a matter of law. Section 3 amends KSA 45-107, permits the Secretary to set the price for session laws, whether published in print or electronic form, without needing to do that by rule and reg, as required by current law. Section 4 amends 45-315. It provides updated language to the process of the printing and session laws, removes language requiring the Secretary of State to provide copies of acts and other matters to the state printer within a certain number of days after sine die, but retains the July 1 date for printing of the session laws. Section 5 provides that publication of the register may be in print or electronic form. This section also amends a matter of notice provided by the Secretary of State for the purpose of notice of proposed amendments to the Kansas Constitution. It permits publication in the Kansas published newspaper of general circulation in a county if in that county there is no newspaper published in that county. And then there's also a provision added that the Secretary of State will certify the amount spent on publication to the Director of Accounts and Reports, and then that amount is transferred from the State General Fund to the Information Services Fee Fund of the Secretary of State. Section 6 removes provisions that the Kansas Register contain descriptions of all pre-filed bills and resolutions and the hearing dockets of our Kansas appellate courts. Also updates some language to reference of subscription instead of paper copies. Section 7 updates language regarding fees for the publication of documents and information in the Kansas Register. Section 8 permits the Secretary to set fees for costs of delivery in connection with the sale of session laws. And also the Kansas statutes annotated, hence the administrative regs and permanent journals of the legislature, again, without the necessity of doing so by adopting a rule and regulation. Section 9 permits the Secretary to obtain printing or binding services in the commercial market in accordance with Kansas purchasing and procurement laws, as previously noted. Section 10 amends the law requiring, with respect to distribution of sets of the Kansas statutes annotated to members of the legislature. These changes would provide that 1 set is to be distributed to each new member of the legislature, and if requested by that new member, the member's name shall be printed on the set. Current law requires 2 sets for each member one of which shall be printed with the member's name. Section 11 removes a requirement that Secretary endorse the time in addition to the date that a rule and regulation is filed with the Secretary. Section 12 deletes a requirement that prices of the Kansas administrative regulations sold by the Secretary must be fixed by rule and regulation. Again, a change to that requirement. And in addition, it adds that the Secretary can recover the costs of storing such volumes in addition to publishing costs. Section 13 allows the Secretary to set prices with respect to replacement sets of volumes of the Kansas administrative regulations sold by the Secretary, again, without requiring that that be done by the adoption of a rule and regulation. And again, we have an addition that the Secretary may recover costs of storing those volumes. Section 14 makes those same changes with respect to the sale of supplements to the Kansas administrative regulation. Section 15 removes a requirement that state agencies that choose to issue guidance documents regarding their procedures for the adoption of rules and regulations with respect to that agency, file an index of such documents with the Secretary of State. Finally, this bill, if enacted, would become effective on July 1, 2021. And Chairman, that is what the bill does.
Any questions for the reviser? Okay, seeing none, we'll start with our proponents, with Katie Kapal, Deputy Assistant Secretary of State. Welcome back to committee.
Thank you, Mr. Chairman. Can you guys hear me okay? Okay, sorry, a little vertically challenged. Chairman Tarwater, members of the committee, thank you for your generous consideration of all three bills before you today. We know it's not fun to work on a Friday afternoon, and we are grateful. I am Katie Kopal, Deputy Assistant Secretary of State for Communications and Policy for the Office of Secretary of State. I appear before you today to testify in support of House Bill 2297. The bill seeks to update the publication responsibilities of the Secretary of State. We are experiencing shifts where consumers, elected officials are preferring their documents. They're shifting from a paper-based delivery model to a more digital, electronic version of receiving documents, and this legislation is an attempt to get us caught up a bit. In 2020, this legislation was introduced as Senate Bill 254. It passed the Senate by a vote of 38-2. It was scheduled for hearings in the House the week you all adjourned early due to the coronavirus pandemic. The bill has 4 key provisions. The first standardizes the pricing mechanism for publishing, storing, selling, and distributing the official publications for the state of Kansas. The second allows our office to seek bids from third-party printers. In full disclosure, this provision was not contained in House Bill 254 last session. We wanted to wait another year to get our feet better under us and learn more about the publishing process, and it just happened to be a good fit for this particular legislation. The third provision allows for electronic subscriptions to the Kansas Register. And fourth, it updates state statute regarding notices of amendments to the Kansas Constitution. So I'll discuss a little bit each of the parts and our intention for each of those. The first is standardizing the pricing mechanisms. As the Secretary of State, as the Secretary for the state of Kansas, our office is required to publish session laws, the Kansas Register, the Kansas Administrative Regulations volume, and full supplemental. We also sell, distribute, and store these publications in addition to the KSA volumes, KSA supplements, and the Senate and House journals. As you will see in our written testimony, the prices are either set by the Legislative Coordinating Council, the Secretary of State, or through rules and regulations. The regulation process in Kansas is intentionally methodological. At a minimum, it takes 114 days for a rule and regulation to go through. Many times, or more frequently, it takes longer than that. However, to set the cost of these publications through rules and regulations makes it very difficult to adequately cover all the cost of the publications, particularly delivery costs, which are constantly in flux. As a result, when it comes to delivery, our office will operate at a net loss because of the current requirement for rule and regulations. So we just want to standardize it. One thing that did come up last year as part of Senate Bill 254 is there was some concern of, are you guys trying to make money on these publications? There is separate statute that limits the pricing of these publications to cover only publishing costs. It is not a money-making endeavor for our agency. We just don't want to lose money on it. The second provision would allow our office to solicit bids, and if we find that they are competitive or cheaper than the state printer, intend to contract with those third parties. Currently, we are required by statute to use the state printer. Since taking office in 2019, we have yet to have a single publication delivered on time and without complication or error by the state printer. Last fall, just as an example, we were notified after the fact by the state printer that they sent one of our publications to a third-party printer. It just doesn't seem right that they can send our publications elsewhere, but we cannot. The state has an established procurement process, and all we are asking for is the ability to seek additional options for printing. Third part would allow the Kansas Register, which is the official newspaper of Kansas, to be offered in electronic form. As part of the shift I previously alluded to, we are seeing our paid print subscribers continually decline. Last year we were at 70, this year we are at 60, and they continue to drop. We believe offering the Kansas Register in electronic form will actually improve distribution and lower costs to our agency. And finally, Part 4 of the bill would update state statute regarding the required publishing of notices, required publishing of amendments to the Kansas Constitution for the 3 consecutive weeks before they appear on a ballot. Current law requires notice to be placed in an official newspaper in each of Kansas's 105 counties. Last year, we worked with the Kansas Press Association to account for scenarios where a county may no longer have an official newspaper in their county, to say if there is no newspaper published in the county, the notice shall be published in a Kansas-owned or Kansas-published newspaper of general circulation in the county. Additionally, the bill ensures there is a process for the Secretary of State to be reimbursed for publishing costs of these constitutional amendment notices. Historically, the legislature has appropriated the funding with 2 exceptions, in 2010 and in 2019. And the reason why that's a problem is we are an entirely fee-funded agency, and if there is not a reimbursement mechanism for those costs, we have to pay for those notices out of our fee funds. So I took a little longer than I intended, but I do thank you for your consideration, and we'd be happy to stand for questions.
Thank you. Committee, any questions? Have you looked at digital only for
We have
constitutional amendment notifications?
not for constitutional amendment notifications. It's certainly something we're not against, but at the same time, we do know not everyone has access, particularly in some of our more rural communities, to digital publications. So it's something we're not opposed to, but we also want to make sure we're fulfilling our statutory obligation to provide notice.
Okay. Seeing no further questions, thank you.
Thank you.
Natalie Bright. Coalition for Opportunity.
Thank you, Chairman Tarwater, honorable committee members. I appreciate the opportunity to be here on a Friday afternoon on behalf of my client, the Coalition for Opportunity. That is a group of employers who work with those who are blind and disabled. And the opportunity to work with the Secretary's office to provide printing is a great opportunity for them. They are constantly looking for work so that they can not only receive the funds for their work, but it goes into their missions, and their missions is to employ persons with disabilities. So working with the Secretary of State would open up some great doors for them. Unemployment for the disabled, I just looked for January of 2021 is 12.6%, double the national average. And so bills like this create opportunities for my clients to employ Kansans. And so we just wholeheartedly hope that you'll take a look at this bill and move it as quickly as possible so we can get more disabled and blind Kansans to move forward. I do have Heather Hogan, who's going to testify virtually, who is one of our members. She is with Envision, who has a keen interest in doing the printing and working with the Secretary of State on future endeavors. So it'll be Heather's first time testifying, I believe, so please be gentle with her. And I'll stand for questions at the appropriate time.
Committee, anyone have questions? Right. Seeing none.
Thank you.
Thank you. We'll move over to Heather.
Hi there. Can you all hear me
Hogan
this
with
morning or
Envision.
this
Welcome to
afternoon?
committee.
Yeah, can you hear me?
Yes, we can.
Okay, perfect. So first of all, thank you to Natalie for the introduction. I appreciate that. And thank you, Chair Tarwater and the honorable committee members for giving me the opportunity to speak to you today in support of House Bill 2297 and the privatization of print services for the state. As Natalie mentioned, I am Heather Hogan. I'm the Senior Vice President of Foundation and Mission Services for Envision. Envision is a not-for-profit based in Wichita, Kansas. We create pathways to independence and quality of life for people who are blind or visually impaired or BVI. We do that primarily through employment opportunities, workforce development initiatives, and rehabilitative services. Our focus is really on holistic treatment of the person so that they not only exist, but live and thrive at both home and work. In order for you to really understand the impact of this bill on an organization like ours, I have to talk a little bit about our operational model. At Envision, we have two different sectors within the organization. One is called Margin, one is called Mission. The Margin side of the house provides revenue for mission-based services, which are vital and crucial to the people that we serve. We have a very large manufacturing operation. In that manufacturing operation, we produce plastic bags, military apparel, and office supplies in both retail, commercial, and government marketplaces. We also have a robust printing division, a full-service printing division. The revenue from these endeavors, the products we produce where we employ blind or visually impaired people for that labor that we sell, supports all of our rehabilitative services, all of our programming, our child development center, our research initiatives, and our workforce development initiatives. This bill gives us the opportunity to create work and to create revenue to support mission services. These services are provided in conjunction with state services and relieves some of the burden of the state in helping care for this vulnerable population. A couple of quick stories for all of you. We have people that move in from out of state often because they cannot find work in other parts of the United States. We have a family that moved in from Illinois. They work in our manufacturing division. Both the mother and father are blind. The children are typically sighted. Without this kind of opportunity for employment that's provided through opportunities like this, they would not be gainfully employed. They were living on welfare. They did not have homes. They did not have transportation opportunities. They could not go on vacations. This has allowed them to grow as a family and provide for themselves in a functional way. Within our rehabilitative services functions, there are hundreds of stories of value that the revenue from these types of opportunities provides in a mission-based environment. We had a child come through our child development center that was blind as a result of shaken baby syndrome. That child went through our early intervention system, went into mainstream schooling, went through our youth programs, was an intern with us at Envision, worked within our workforce development center, has now graduated from Wichita State University with a degree in communications, and now works with us in our workforce innovation center. Those are the kinds of pathways that these kinds of opportunities provide for the people that we serve. And I just want to say that I commend the committee and the Secretary of State's office for their consideration of this bill. It is meaningful in more ways than I can express. Thank you so much for your time, and I would be happy to answer questions if you have them.
Would have never known it was your first time. Good job. Committee, any questions? Seeing none, thank you very much.
Thank you.
Committee, you have some written testimony from the Kansas Press Association, Kansas Chamber, and Wichita Chamber, all in favor of this bill. We're not showing any neutral or opponent testimony today, and so we'll close the hearing on HB 2297. With that, we'll open the hearing on HB 2298 and get a information update from Charles Reimer, our reviser. Thanks.
Thank you, Chairman. I've also provided a memorandum on this bill, which should be in your materials. HB 2298 changes and updates service of process provisions associated with the Office of the Secretary of State. Section 1 addresses service of process provisions for non-residents who operate motor vehicles in Kansas. Under Kansas law, a non-resident driver in Kansas is deemed to have appointed the Secretary of State as their agent for service of process with respect to any accidents. And there is an updated process in this bill that provides that the plaintiff may serve a non-resident defendant by providing the Secretary of State with court documents and the last known address of the defendant and paying a fee. Secretary then mails the documents to the defendant by return receipt delivery. There's an alternate procedure that the plaintiff may personally serve the defendant outside the state by having the documents delivered either by an adult person, not a party to the suit, or by an officer qualified to serve legal process in that jurisdiction. The plaintiff then notifies the Secretary of State that service has been made and provides copies of the documents served. There's a provision that compliance with the procedures will constitute sufficient service from the defendant, and the Secretary keeps a record of all process served. Section 2 adds domestic and foreign limited liability partnerships to the provisions governing service of process and business entities through the Secretary of State. Under current law, businesses who are authorized to conduct business in the state are deemed to authorize the Secretary of State to accept service of process on their behalf in circumstances where the service cannot be made on the business's resident agent. And that is what the bill does.
Thanks, Charles. Committee, any questions? Seeing none. We have a proponent here, Clay Barker, Assistant Secretary of State.
Thank you, Mr. Chair. This is a pretty straightforward bill, and I'll quickly explain the reasons why we feel it should be adopted into law. It has two parts, as the reviser mentioned. The first part has to do with the special circumstances where a non-Kansas driver comes into Kansas, has an accident, goes back to their home state, and the Kansas victim wants to file a lawsuit. And you do that by going to court and filing the lawsuit, but then you have to get the service of process. That's the lawsuit and a summons from the judge served on that out-of-state defendant. And in 1927, I won't make this a history lesson, but the U.S. Supreme Court said it was perfectly fine for a state to pass a law that says, by the mere act of driving on our government roads, you have made the Kansas Secretary of State your agent if you get in an accident in our state. And if you're an attorney, you might remember that was the case that came after Penoyer v. Neff, if you're in civil procedure. And Kansas adopted that law in 1935. So all a plaintiff has to do is they fill out a lawsuit, they file it, they take it to the Kansas judge, they show, here is the, for instance, Missouri defendant, where they live, a car was involved, and describe the time and place of the accident. The judge signs the summons, the plaintiff brings it to the Secretary of State, pays a fee, and we mail it to that defendant and try to get it served. What this statute does is it gives an alternate procedure.
Sorry, Clay, could you get a little closer to the microphone? The people online are having a hard time hearing you for some reason.
Is this better?
Thank you.
Okay. So the current process is the plaintiff files the lawsuit, goes to the judge, shows the name of the defendant, say a Missouri resident, that a car was involved, when, where, and the judge signs the summons. The plaintiff brings it to the Secretary of State. The Secretary of State, being deemed the agent for that Missouri driver, can then mail it to them and service is completed. Sometimes there was problems with that where the Missouri resident just couldn't be found and the Secretary of State wouldn't be able to chase them down. What this bill does is it gives an option that many states have already adopted that allows that Kansas plaintiff to do personal service on the, for instance, Missouri resident, hire a process server to go find them and get them served, and then just come and tell the Secretary of State. So this just gives Kansas victims a second option to serve a lawsuit. Doesn't change any existing rights. And the second part is just in the rules of civil procedure, there's a long list of methods of how to serve people, individuals, minors, government. And in the section on how to serve business entities, it was just an oversight in the past that limited liability partnerships were not listed, along with all the other types of business entities, limited partnerships, general partnerships, LLCs, corporations. This just fills in that omission. That's my testimony, Mr. Chair. I'll stand for questions at the appropriate time.
Seeing no questions. Thank you. Committee, we don't have any other proponents, no neutral, and no opponents, so we can close the hearing on HB 2298. And we will open the hearing on HB 2391 and get a update from the reviser, Charles Reimer.
Thank you, Chairman, members of the committee. Again, I provided a memorandum on this bill. So this is a bill from last year as well. This was Senate Bill 251 from last year, and this bill combines Senate Bill 251 with some provisions of Senate Bill 424 from last year. One of the main things the bill does is provides for a biennial filing requirement and fee requirements for business entity information report. So this is a process and a regime that replaces the current system where you have annual reports filed with the Secretary of State. The way it's set up is that businesses that file formation documents in even numbered years, the Secretary would file the report biennially in even numbered years, and business entities that file their formation documents in an odd numbered year would then go ahead and file the report in odd numbered years. The bill makes changes to all the references in the relevant statutes pertaining to the Secretary of State's filing requirements and business law provisions, changing the term of annual report to business entity information report. The fee requirements are also changed to reflect the new 2-year system. So the statutory fee is doubled from $40 to $80, and then plus the amount specified in rules and regulations of the Secretary multiplied by the number of tax periods included in the report. This procedure, this new biennial filing regime takes effect on January 1st, 2023. And I've noted a number of sections. Most of the bill actually is about that change, either changes in law with respect to substance or just for conformity, changing the name of the annual report. The bill also makes some technical corrections to some sections or statutory references. There are a few other things the bill does. Section 5, page 4, clarifies that the name of a professional association may be abbreviated as either PA, P period, A period, or PA. Section 6, in addition to making changes pertaining to the biennial report, also requires that the official title or positions of the individual signing that report are to be designated. And that's also a requirement that's found in Section 13, Section 14, and Section 15. Section 10 deletes a reference to an obsolete statute that pertains to tax filing extension documents. that are no longer filed with the Secretary. Section 12 pertains to extensions, renewals, or reinstatements of articles of incorporation or authority to engage in business. That current law is amended to no longer require the date of the filing of the original articles of incorporation when a business seeks to do that by filing a certificate with the Secretary to extend, renew, or reinstate. Other changes conform to the biennial filing regime in that section. And then there's a change with respect, basically in conformity with that new system, that corporations seeking to renew or reinstate only have to file business entity information reports for up to the 5 most recent reporting periods. And nonprofit corporations need only file for the most recent reporting period instead of the current provisions there that deal with annual reports. Section 24 is amended to permit electronic signatures for filing of certain business documents with the Secretary of State. That's also the case of Section 29 that permits electronic signatures. Section 32 removes some obsolete exceptions to the Open Records Act, including for non-disclosure of income tax extensions that were previously filed with the Secretary. Section 38 provides that with respect to partnerships and the addresses that must be provided to the Secretary. There's a new definition for street address, and it means location with a number, street, city, state, and postal code. Section 43 pertains to UCC filings, and it provides that when a Social Security number is improperly placed in one of those UCC filings by the filer, that Social Security number may be disclosed in such filings, which of course are public record. They're filed for public record. So current law would prohibit that. This permits improperly placed Social Security numbers to be publicly filed. The bill also repeals certain obsolete statutes, including in particular some statutes that obsolete statutes that required blanket music licenses to be filed with the Secretary. The bill is effective July 1st, 2021, if passed. As noted, the provisions pertaining to the biannual business report filing system are not effective until January 1st, 2022. That is what the bill does.
Thanks, Charles. Any questions for the revisor? Seeing none, we'll call up Clay Barker one more time.
Thank you, Mr. Chair. It's great to be back. And I just realized that 3 of the representatives here have the districts that are south, west, and north of me. I almost feel at home. HB 2391, as the revisor mentioned, it's mainly a cleanup bill, and it makes some modifications to current processes that we feel are small business friendly. They're revenue and fee neutral, nothing changes, but it just helps out small companies. It has 7 major areas, but the first 3 are pretty small. One, it just defines that when a statute requires a street address, that actually means a number, a street, city, town, and zip. Some people just don't fill it out properly, and there was no defined term in the statute. Second, and this sounds just like bureaucratic nonsense, but sometimes professional associations file their corporate name with the letters PA in it, and when they get their certification from their professional association, it may have P period, A period. I know that seems like it should be identical. The way the statute's currently written, that's 2 different names, and we have to tell them to go back and get another certification, which is very annoying. This statute would simply clarify that PA and P period, A period are the same thing. And every other abbreviation in the corporate code, LC, LLC, have that provision. The third part is it defines its signature. In most business statutes, an electronic signature is sufficient. That's generally the policy of Kansas, but we just wanted to specify that is acceptable in corporate documents. Moving on to some provisions that are a little more substantive. Since 1939, Kansas has required that blanket music licenses are filed with the Secretary of State. And what that means is any small business that wants to play music in the background has to buy a blanket license from these two large organizations, either BMI or ASCAP, and you pay $100 a month and you can play any piece of music on their list, millions of songs. And the result is every year I get about 2 feet of filed paper documents of every license in Kansas. It goes in a drawer, and after 2 years we send it off to the archives. No one ever looks at them. The entities in New York tell us that we're the only state that requires this. The lobbyists for the businesses that get these licenses have no idea why we get paper copies of the licenses. They didn't even know we had them. And I believe it's just a complete waste of effort on both the blanket music groups and the Secretary of State. And in fact, one of the lawyers from the large organizations called me up 2 or 3 months ago. He sounded annoyed and said, "Are you the guy trying to get rid of this filing requirement?" And I said, "Yeah," and I thought he was mad at me. And he goes, "I will do anything to help you get rid of this because they're worried that there'll be some change in their organization and they will forget to file it in Kansas and they'll be in trouble." So I think this is just an example of eliminating government waste that just sort of is there because it's just a legacy. The fourth one is a protection for our staff. There are individuals called sovereign citizens that for some reason believe that a person, and these theories vary a lot, has two entities, your federal and your real person, and that your social security number is actually a secret bank account with the U.S. Treasury. And if you file certain Uniform Commercial Code documents, then you can pull money from this secret treasurer's account and then issue documents to pay bills, and if people don't accept it, your debt's free. And a lot of prisoners do this. We get a lot of filings on this. And the problem is when they do their Uniform Commercial Code filing online, they often put their Social Security number in the document. There's no place for a Social Security number in the documents. In fact, there's a warning not to put it on there. Sometimes they'll put an attachment that's 20, 30 pages of handwritten notes, and there's a Social Security number on there. And by filing it, it automatically becomes a public document. Well, there's a state law that says if you allow a Social Security number and name to become a public document, the employee can be fined for allowing that to happen. And we would just like an exception to that statute, and there's a few other exceptions that says if a Social Security number is put in a Uniform Commercial Code filing inappropriately, that our employees will not be fined if it becomes a public record. Right now, we get about 150 to 200 of these filings a year. It takes an hour or 2 or 3 of staff time to hunt through it, trying to redact Social Security numbers, and we're not always sure if we're successful, because again, a lot of these are handwritten documents, or the number looks like some fake bank account, and it's just a protection for our staff. The sixth is the biannual filings. I think the revisor covered this, that instead of filing an annual report with the Secretary of State's, companies will now be allowed to file it every 2 years. This is revenue neutral to us, and it's also fee neutral to the companies. This just makes it a little easier on them. They don't have to constantly be filing, and we'll be giving them notice of the change. And the last piece is reinstatements. Is sometimes corporate entities forget to file these reports, annual reports, and so their authorization to do business in Kansas wanes, and then they can bring it back by reinstating their corporate existence. And the problem is the 2% of these, and we get about 4,000, 5,000 a year that want to reinstate, is that some of them are decades old. A company was formed in the 1930s or 40s and somehow waned, and now it needs to be brought back to life, and they can't find all the old records. This statutory change would limit it to just the past 10 years of filings, annual reports, and then you just pay the fee for those. And the reason this can come up, if you wonder why so long ago, is sometimes grandpa had a house, but the house wasn't owned by grandpa, it was owned by grandpa's LLC. Family forgets about it. 40, 50 years later, they want to sell it, and the lawyers looking back over the records say, well, grandpa didn't own it. This LLC owned it, and you let it fade. We have to reinstate it so that it can properly sell the house. And again, this doesn't come up a lot, but when it does, it's tough on people, and this statute would make it a lot easier on these small corporate entities to get reinstated and go back to doing business. We just see it as small business friendly and cleaning up some bureaucracy in the system. And Mr. Chair, that's the 7 points in this bill, and I'll stand for questions at the appropriate time.
Thank you. I have a few questions on that last point. We'll start with that. Annual filing, so if someone has a corporation or an LLC that they failed to renew and forgot or died or however you put it, and they're 8 years into it, do they have to go back and do each year's filing and pay a fee for each year? Or can they just file that 8th year and become back into being a corporation?
Right now, they ask for a certificate of reinstatement, and to get that, they have to file the annual reports back until they get back to the original one that was valid, and then pay a fee for each of those. Now, 98% of reinstatements are only a few years where they let it lag, but some of them go back quite a ways.
And does this change that so that they don't have to pay those fees or do the reports for the
They'd only
last
have to
8
pay
years?
the fees for the last 5 filings, which would, because this bill makes it biannual, would be 10 years worth.
Okay.
And that sort of it brings the entity back to life. It ratifies that it was in corporate existence for the past 10 years.
Okay, and then you said this was, the biannual part was revenue neutral and fee neutral. So are you charging twice as much for every 2 years now, or how does that work?
Correct. So if the fee was $5 for an annual report, it would become 10, but you only would file it every 2 years. So the companies would be paying the same net amount, and the Secretary of State would have the same net revenue.
What is the fee now?
If I could ask my colleague Jennifer, who's the head of our business services.
So you said if it was $5, it's
That was an
probably not $5. I think it's 60, right? Something like that. Or...
Good afternoon, Mr. Chairman. The fee for a for-profit entity is $55 for an annual report. $15 of that goes to the Secretary of State, $40 goes to the State General Fund.
Okay, in an LLC?
LLC is the same.
Okay, great. Representative Long.
Thank you, Mr. Chairman. Can you hear me all right?
We can hear you, barely.
Thanks for being here, Clay. My question was, the bill's enacted on July 1st, 2021. So my question is, and then the filing regimes are not effective till January 1st, 23. So my question is, when do S Corps and LLCs and such start paying every 2 years? Did they start that in 21, and is it on even or odd years? I'm a little confused about that.
Clay, you want to answer that, or do you want the revisor to?
Ms. Cook might be able to give you a more precise answer, but I believe the intent is they would start paying in 2023. That gives us time to give notice and education to the corporations.
Okay. All right.
So is the second part of that question was even or odd? Does it just matter which year you start in, or how does that work?
Right, when you'd file these new biannual reports, it would depend on when you initially were incorporated. So if you were incorporated in an odd year, your biannual would be in an odd year. If you were incorporated in an even year, your biannual would be in an even year.
Oh, so it goes back to the original filing. So that way you're not going to have every current corporation every 2 years at the same time.
Correct.
Okay. Representative, did that make sense to you?
Yes, it did. Thank you, Mr. Chairman.
Okay. Representative Kessler.
Thank you, Mr. Chair. Real quick question for individual. Can you hear me okay?
Yes, we can.
All right. Thank you. For individual who has like multiple LLCs and have filed multiple, throughout, years of span of time. I mean, is there a mechanism there that they can actually group those together where they can all have the filing, the same type of filing date? Is there some sort of vehicle for that as well?
Well, each LLC, unless it's a series LLC, which is a little different animal, is its own independent entity. So it would have to, what year it would file its biannual report would depend on when it was initially incorporated.
So the answer would be no, there's not a mechanism currently to group them together.
Correct. If there's one owner of multiple LLCs, that one owner just can't file them all at the same time.
Okay. Any further questions? Representative Johnson.
Thank you, Mr. Chair, and I'll actually change up and follow up. I like the idea that the former representative mentioned, and while I know that's not the way we're set up, I don't know if there's any way that somebody could file an appeal to that, to group 2 or 3 together and not have to file every year or not. I'd appreciate if we'd take a look at that, because otherwise, I really think this is a good help. I appreciate the work to look at how to streamline this and make it work better for a large number of folks, and that might be yet one more good step. I was also curious, and that's actually the most important point, is thanks to the team that worked on it. But second, were there any other options on, let's see, I think the 5th point that you had mentioned that dealt with that Social Security number issue? Were there any other ways that we might be able to make that easy and reasonably protect staff and try and get those numbers cleaned up? I appreciate taking the punitive stuff off, but anything else we could do to help get rid of the issues that happens when somebody sticks those on the wrong form?
Representative, we couldn't think of anything because again, the form doesn't have a Social Security number blank. You could just immediately redact, and there's a warning on it not to put it there. And when these individuals put their Social Security number on it, like I said, sometimes it's handwritten, it looks like a bank account number, and we do make an effort to get it off of there. But because of the statute, it's hard to find, and it takes a long time of staff time. And I don't know if there's bad players out there that look through UCC filings trying to find Social Security numbers of these individuals, but they do get through, because as soon as you file online, it becomes a public record immediately.
And to follow up on that, you still will be making every effort to delete that or to redact those, right?
Yes, you can usually tell a sovereign citizen because they have little tells on their mailing. They put a copyright symbol after their name, red thumbprints, and the zip code has brackets around it. It's all part of their, I don't quite get their theory of the world, but so they stand out, but just hunting through all these documents to get them is sometimes difficult to get the Social Security numbers off.
Okay. Seeing no further questions, committee, we don't have any neutral or opponents to this bill either, so we can close the hearing on HB 2391. And I've got a question for staff. Either Charles or Eddie could answer this. In the interest of saving time, not necessarily in here, but when these bills hit the floor, I would like you guys to try to figure out a way to see if we can combine any of these together, or hopefully all 3 of them together. So we only have to have, one hearing on the floor to get it over to the Senate. So if that's possible, I'd like you to try to find a way to do that. Any theories there from either one of you?
In case Charles is waiting on me, I guess my comment would be that our office usually defers to the revisor's office on questions of single subject type rules.
Okay, yeah, Charles, I don't mean to put you on the spot there, but do you think that's something that we could do?
Chairman, I would have to take a closer look at that offhand. I would say that may be difficult. 2297 deals with, I guess one could say they all concern the Secretary of State, but 2297 deals with publications, service of process, business entity filings. The subject matter is somewhat different for each bill, but I will take a closer look at that and maybe discuss it with other folks here in the revisor's office and get back to you on that.
Okay, I'd appreciate that. There are all three Secretary of State bills, and they're all three cleanup bills, so maybe that'll work. All right, committee, I want to remind you, Monday is Senator Estes' funeral, so I know some of you won't be here. We will not be voting on anything Monday, but we do have 2 bill hearings, and so if you are able to listen in, listen in. If not, I would ask you to listen in at a later time, because both of those bills, you'll probably see them later in the week. With that, we will adjourn.